Hello, everyone. Thank you. This is a big old crowd. First I would like to say thank you to the Lincoln Douglas Society for the invitation. I'm going to be picking up on some of the themes that have already been covered, but hopefully from a unique angle. And an additional note, the books at issue are referred to as LGBTQ plus inclusive, and I will refer to them that way for consistency. The first thing I want to say is that if you are interested in these issues, and I'm assuming you're here because you are, I would like to ask that you investigate these further, because as I was learning about this, I realized that the legal complexities and implications of this decision are far too numerous for us to address in this debate. These issues include, but are not limited to, what the government's obligations are once it elects to provide a public good, such as public education, whether and under what conditions we can impose limits on that public good, whether a family's financial constraints impacting access to educational alternatives is relevant to these questions, how the age of the students impacts our analysis, and what preconceived notions we have regarding how children of different ages receive and integrate information and social norms, what rights do the children have as opposed to the parents in terms of free exercise of religion, free association, and access to ideas, and the host of other topics that I do agree with Mr. Coleman that parents want their children to be educated, but this does open us up to challenges on other topics that could be considered hostile to a parent's faith, such as evolution, climate change, myths and holidays, vaccination and blood transfusion, feminism. There's a whole host of topics that could be challenged under this doctrine. Obviously, that's a lot to cover, and we can't possibly address it all and try to convince you to vote for our side of the proposition. So first, I'm not going to try to change your mind about the proposition, because I agree with Professor Brown. I feel like that's a value judgment. So what I want to tackle is the reasoning that the majority used to arrive at their decision to grant the parents an injunction, and why I found that reasoning concerning, and how these two ideas, inclusivity and free exercise of religion, need not be in conflict. So, a little bit of history that I had to learn to make sense of this case. Prior to this decision, the Supreme Court has held that compelling a student to declare a belief contrary to their own religious views is a violation of their right to free exercise. That's the Barnett case that's been referenced. Short of such an affirmative compulsion, the court has held that exposure to ideas that conflict with one's religious beliefs doesn't rise to the level of coercion, such as when the court held in Kentucky v. Bremerton School District that students being exposed to a coach's prayer at a school-sponsored sporting event didn't violate the Establishment Clause. As the majority explained in Mahmoud, the first consideration in an analysis of whether a student's free exercise has been violated is typically decided according to the standards set forth in Employment Division v. Smith, in which the court held that the government can place incidental burdens on religious exercise as long as the burden is neutral to any specific religion and generally applied. Under that test, the introduction of LGBTQ plus inclusive books into a school curriculum would likely survive a challenge such as the one presented here. The books don't target any particular religion. The parents bringing suit are in fact Ukrainian Orthodox, Catholic, and Muslim, and the books are used in the same way as the other 80 to 90 approved texts per grade level. In other words, exposing all students to books including characters and ideas that may be objectionable according to any particular parent's religious beliefs would be neutral, and exposure to the ideas alone wouldn't rise to the level of coercion. Therefore, according to that precedent, participating in the curriculum, including the LGBTQ plus inclusive books, would not violate a student's right to free exercise of religion. However, and this is why this case is interesting, the court made the pointed decision to proceed differently, and they relied heavily on a case that was previously considered an exception to the general rule. In Wisconsin v. Yoder, which we've heard about, the court held that a group of Amish families had the right to remove their teenage children from public education entirely because mandatory school attendance substantially interfered with the religious development of the children and created, and I'm going to put this in quotes because these are not my words and they come up again, a very real threat of undermining. So that's not a derogatory gesture. I just want to get that language. the religious beliefs the parents were attempting to teach their children. Yoder was recognized as an exception to Smith because the neutral, generally applicable compulsory education laws affirmatively compelled the parents to send their children away to school when their religion dictated that they be integrated into the Amish community at home. This exception is consistent with the Supreme Court's previous line between exposure and compulsion. In Mahmoud, the court used the Yoder exception to Smith to apply the very real threat of undermining test in a much broader context, thus bypassing the neutral and generally applied question entirely. This is a much easier showing on the part of parents who can now challenge school curriculum based on a claim that the curriculum conflicts with their religious beliefs and poses the very real threat of undermining the religious education of their children. Hence, the potential application for the ability of schools to expose children to a wide range of ideas mentioned above. So what do we do about this? If this is to be the new test used to determine on what grounds a parent can challenge school curriculum, we must ask whether it's possible to expose students to ideas that conflict with parents' beliefs, or if all such exposure automatically rises to the level of threat. So basically, if this is the test, how do we know when we've met it? This question is surprisingly complex, and I will illustrate with an example. The court stated that the determination of whether a given law or policy substantially interferes with the religious development of a child will be fact-intensive. In this case, the majority opinion pointed out that the LGBTQ+ inclusive books are being presented to elementary school children by trusted authority figures, teachers like me, so trust me, and are normative in nature. In this case, the court defines normative as meaning, direct quote, clearly designed to present certain values and beliefs as things to be celebrated and certain contrary values and beliefs as things to be rejected. One book, and I have pictures, one book, because the pages were cited by both the majority and the dissent, is Uncle Bobby's Wedding, intended for 5th grade children who are typically around 10 to 11 years old. Give me 1 second here. He already taught me how to do this, so let's see if I disappoint him. All right. So in Uncle Bobby's Wedding, Chloe has a very close relationship with her Uncle Bobby. They do a lot of activities together. And at one point, there is a summer picnic where Uncle Bobby and Jamie announce that they are getting married. And everyone's so excited, except for Chloe. And then this is how Chloe's mom explains why people get married. Bobby and Jamie love each other, said Mommy. When grown-up people love each other that much, sometimes they get married. Okay? The majority states that this presents a specific, if subtle, message about marriage. The book does not simply refer to same-sex marriage as an existing practice. It presents acceptance of same-sex marriage as a perspective that should be celebrated. All right, but let's read the book again. Chloe is very close to her uncle. All right, he announces that he's going to get married. What if Jamie were a woman? Chloe's still pretty sad. And then Mom explains that sometimes when people love each other, they get married. All right? So the question is, if Chloe is jealous because she thinks Uncle Bobby will spend less time with her, then is the gender of his partner relevant to the story? Is this a book with a subtle message about the acceptance of same-sex marriage, or is it a book about childhood jealousy and a growing family in which the married couple happens to be of the same sex? To put this in additional perspective, according to the Montgomery County Classroom Textbook Order List, each grade level between kindergarten and 5th grade has 80 to 90 approved supplementary texts. And as we've discussed, 13 LGBTQ plus inclusive books spread across those grade levels was added to the curriculum. Presumably, most of the other depictions of marriage within the supplementary text present many examples of happy opposite-sex married couples, maybe some divorced couples or other extended families. Uncle Bobby's Wedding is normative in that it exposes students to a single example of a happy same-sex couple. But that begs the question, does one book pose a threat? Does 13? What does exposure without threat look like? Also, notably, the alternative to a normative text is one that is descriptive, so would teach children directly about things like same-sex marriage. That could include something like a history text that describes the national legal recognition of same-sex marriage. Would that type of direct instruction also be a threat? We don't have an answer to that based on this decision. But we're now in a world where we are uncertain as to how broadly this new test applies and when exposure to an idea rises to the level of threat. How do we get out of this conundrum? How do we find a way forward? I think the answer actually lies in the Montgomery County curriculum. I am almost done. All right, this is my last visual. So this is from another book from Mahmoud, and the majority opinion cites the curriculum guide, and the student says he can't be a boy if he was born a girl, and the teacher's told to respond, that comment is hurtful. However, in the full text of the guide, the student says, that's weird, he can't be a boy if he was born a girl. And the teacher is told to reply, that comment is hurtful, we shouldn't use negative words to talk about people's identities. The guide addresses the impact of a potentially hurtful comment and acknowledges the difficulty the speaking student is having. Inclusivity in schools makes space for both realities and experiences at the same time, with both students exposed to the ideas and existence of the other. In fact, the curriculum guide even goes so far as to specify that the aim is not to change the student's religious beliefs. But inclusivity itself, as expressed in the curriculum guide, offers us a possible solution. So I'm going to end with a quote from the curriculum guide. A student might say something like, being gay, lesbian, queer, etc., is wrong and not allowed in my religion. The teacher can respond with, I understand that is what you believe, but not everyone believes that. We don't have to understand or support a person's identity to treat them with respect and kindness. School is a place where we learn to work together regardless of our differences. In any community, we'll always find people with beliefs different from our own, and that's okay. We can still show them respect. So with that quote, I will end and ask that you consider voting yes for inclusivity.